two different types of contractors, or you could say three, but realistically we're going to focus on two. Hello everyone, welcome to this week's class. So this week we will be covering chapter 3. Now chapter 3 goes really into depth in regards to the protections the license offers you. So keep in mind, without a contractor's license, you have no protection under the law. But with the contractor license, you have various different protections in the event that a contractor refuses to pay you or a client refuses to pay you. The very first thing I want to talk about before we actually start the chapter is discussing the two different types of contractors, or you could say three, but realistically we're going to focus on two. If you are the prime contractor, the prime contractor has the contract directly with the client. Okay, so I'm going to say that again. The prime contractor has the contract directly with the client. Okay, in most cases, the prime is a general contractor. However, there can be situations where a painter or an electrician or a landscaper can be considered a prime. So for example, if the client just needs a painting job, they're not going to hire a general to do a painting job. They're going to hire a C33 painting contractor. If that is the case, then the painter would be considered the prime because they have the contract directly with the client. So above all else, that is who the prime is. The prime has the contract directly with the client. Okay. Now the prime can also be known as the original contractor, the direct contractor, the general contractor, or just contractor. But what I really want you to focus on is they have the contract directly with the client. Now, if you are a subcontractor, keep this in mind. If you are a subcontractor, you still need to have a license, okay? But the subcontractor has the contract with the prime. So a sub does not have a contract directly with the client. A subcontractor has a contract with the prime contractor. Same can be said with a supplier. A supplier would not have a contract with the client. A supplier would have the contract with the prime. Okay, so now that we have that cleared up, let's go ahead and start chapter 3, page 7. Chapter 3, page 7. Now, the reason why we do not go over 1 through 6 in this chapter is because pages 1 through 6 is a summary of the entire chapter. The real chapter doesn't start until page 7. So if you review pages 1 through 6, you're going to see that it's pretty much a summary of the entire chapter, which is why we start on page 7, where it says preliminary notices. The preliminary notice is primarily used by subcontractors and suppliers, which is why at the top of page 7, I want you guys to put subcontractors and suppliers. Now, there's a lot of information on this page, a lot of great information, but what I want you to focus on are my key points. A lot of this chapter, I've summarized it into a lot of key points. Makes it a lot easier to understand, and you know really where you need to focus your attention at. Now on page 7, of course, we're going to discuss the preliminary notice, but I did a couple questions and answers for you guys. So number 1, the preliminary notice is primarily used by subcontractors and suppliers. So when you guys think of preliminary notices, the first thing that should pop in your head is subcontractors and suppliers. Now, what is this form for? This form has a bunch of different uses, but this form establishes your right to the mechanics lien and the stop notice if the contractor refuses to pay you or the client refuses to pay you. So this form guarantees your right to your payment. If you don't give this form, you could have lost your payment. You could have lost your money. So where I want you to focus, what is this form for? This form establishes a subcontractor's and supplier's right to the lien and the stop notice if you remain unpaid. It also alerts the client that subs and suppliers are also working on the property. Remember, the client has a contract with the prime. They could be unaware that subs and suppliers are also working on their property. But when you send them a preliminary notice, that alerts them, that tells them a subcontractor or a supplier is also working on that project. Remember, a preliminary notice is not a bad form. It's a good form. It's alerting the client, hey, I'm a sub, I'm not suing you or anything, but I'm also working on your property, so keep that in mind. What else do we have to know in regards to the preliminary notice? Who do we have to provide a copy to? So as a subcontractor, you have to provide this form. To who though? You're going to provide a copy of the preliminary notice form to the prime contractor, which is the person who hired you, the client, the lender, if there's a lender. If there's a bank that gave a loan to do the project, you're going to give them a copy of it too. The only one that's optional is the county recorder's office. So let's go ahead and repeat that information one more time. Who do we provide a copy to? We're going to provide a copy of the preliminary notice to the prime, the person who hired you, the client, the owner of the property, the lender, the bank, if the bank gave a loan to do the project. The only one that is optional is the county recorder's office. The next question, when do we provide a copy of the preliminary notice? When do we provide a copy? Now, the state has something very particular, certain terminology. That terminology is when you first furnish labor and materials. When you first furnish labor and materials, which basically means the day you start work or when the materials arrive at the property, whichever comes first. So, for example, if you signed the contract on Monday and you started the work on Thursday, that means you're providing this form on Thursday. Because I'm going to repeat this. It's the day you start the work or when materials first arrive at the property, whichever comes first. Okay? Now, it's the day you start the work or when the materials arrive at the property or within 20 days. My recommendation, the day you start the work, obviously, or when the materials arrive at the property, so you don't forget. But from that day, you have 20 days in total to provide that form. After 20 days, you are possibly losing money if the client or the contractor start to refuse payment. So what you want to record in your head and in your notes, when you first furnish labor and materials, which in English terms, the day you started the work or when materials first arrived at the property, or within 20 days of that day. Now, we're going to move forward to page 8. Now, on page 8, I want you to highlight the very first sentence, and we're going to go ahead and read it. A subcontractor who does not serve a preliminary notice loses both stop payment notice and mechanics lien rights. We already covered that, right? In the second paragraph, go ahead and highlight that first sentence where it says, if a subcontractor's share of the total contract amounts to more than $400, the sub is actually required by law to file a preliminary notice. So you are required by law to send this form out to the required parties, to the prime and to the client, to the lender. If there's a lender, the only one that would be optional would be the county recorder's office. I see this issue or this problem happen with a lot of contractors after they get their license. They kind of revert back to what they were normally doing. Remember, this is your responsibility as a contractor, as a business owner, as a person that has the license. This is your guaranteed protection in the event that a contractor refuses to pay you or a client refuses to pay you. On page 8, this is an example of the preliminary notice form. On page 8, this is an example of the form. Please study the form and the notes. This is the best way to understand this form. If you study the notes, the questions, everything I gave you, you're going to understand how to fill it out and what are the most important parts of this notice. Now on page 9, this is just a sample of the preliminary notice. This is just a sample cover letter. It is not needed or required by law, but this is a softening of you giving the preliminary notice to a client. Some clients aren't aware that you are required to give this form. Some clients even get scared. Oh, wow, you guys are going to sue me, or you guys are going to put a mechanics lien on my property. No, the cover letter is just letting them know I'm just a sub, but I'm also working on the property. So it is your responsibility as well to make sure that your contractor pays me in full. All right, guys, now we're going to go ahead and move forward to page 13, and we're going to discuss the mechanics lien. Now, the mechanics lien is a very important form. It's a very important protection that the license offers you. So we're going to go ahead and start in the very first paragraph. And I do want you to highlight that very first sentence where it says, the purpose of a mechanics lien is to provide real estate as security for the payments of unpaid bills for goods and or services. Now, I'm going to tell you exactly where to highlight. I'm going to give you their definition, and then I'm going to try to break it down in an easier way for you guys to understand once we go through all the paragraphs. Now, in the second paragraph, I do want you to highlight the first two sentences, and we're going to go ahead and read that as well. A variety of persons are entitled to file a mechanics lien. Claimants include, but are not limited to, licensed direct contractors, licensed subcontractors, material suppliers, lessors of equipment, laborers, and a design professional such as architects. So these are the people that have the opportunity to submit a mechanics lien if they remain unpaid. Okay. In the third paragraph, I want you to highlight that first sentence where it says, if you are a direct contractor, you must record your claim of a lien after the contract is completed. So if you are a prime contractor, you have to complete the project in total in order to have the opportunity for the mechanics lien. Subcontractors or material suppliers may record a lien as soon as they finish supplying goods or services to the property. So you also want to highlight that second sentence. So if you are a sub, as soon as you finish your work, if you realize you're not going to be paid, you too can place a mechanics lien on the property. If you are a supplier, as soon as they install your materials and you realize that they're not going to pay you, you can actually place a mechanics lien on the property at that time. And in the last paragraph, I want you to highlight that first sentence where it says, unlike material suppliers, manufacturers of construction materials are not entitled to file a mechanics lien. So this is just giving you an example of someone that cannot place a lien on the property. It's a very specific example as well. I personally seen that question when I took my state exam. They did give me that option, who cannot file a mechanics lien on a property. So make sure you highlight that sentence. Please study everything I'm telling you to highlight, or go back to your notes and review your notes, which is a summary of the most important parts in the book. As you can tell, in this chapter, I'm really combining the both because I know this chapter is very confusing. So what really helps you understand it is if you're focusing on my key points, because those are the most important parts in this chapter anyway. Now, I did tell you I was going to try to break it down in an easier way to understand. So for example, at the very top of the page, when it's giving you an example of the mechanics lien, a definition of the mechanics lien, it says the purpose of a mechanics lien is to provide real estate as security for the payment of unpaid bills for goods or services. Basically, you also can say it's a hold on the title of the property. The example I like to give here is, let's say, for example, you take out a car title loan, which is basically you give the title of your car, you take out a loan with it. What happens if you don't pay that loan back? They can actually repossess your car. Very similar to the mechanics lien. You're literally getting a hold on the title of the property. If the contractor or client refuse to pay you, the property will be seized and sold in a court auction in order to pay you that money. Sorry. Now, the mechanics lien is used when a contractor or client refuse to pay you. So this is not something that you're already threatening your client beforehand, right? This is something that will be put into use if the contractor is refusing payment or the client is refusing payment. So this is not something you're going to do on a daily basis. The mechanics lien is an extreme measure to recover your money. Now, what are the consequences of having the mechanics lien? We will discuss that in the next page. But just to give you guys a quick breakdown, the client cannot sell their property, they cannot refinance the property, and they can even lose the property in the foreclosure lawsuit. So there are some extreme consequences of having a mechanics lien on the property. It is not something that the client is gonna forget about. It's a very serious consequence. And what I always like to say is nobody wants to risk their property for a couple $1,000s, right? And if we divided the project the way we should have into phases, hopefully that last payment isn't a lot of money that's going to be owed to you anyway. But at the end of the day, you have that protection of the mechanics lien. Now, going over to page 14 and page 15, we're going to be under where it says requirements. Now, I do want you to highlight every single bullet point. Every single bullet point is important. It's basically just letting you know what information has to be on your mechanics lien when you're filling out the form. I will show you on the next few pages the examples of that form, but let's go ahead and start. At the bottom of page 14, under where it says requirements, this is an example of the information that has to be in your mechanics lien. The very first bullet point, a statement of the amounts of the money owed. So if the client owes you $10,000, $15,000, $20,000, that information should be found in your mechanics lien form. Name of the property owner or the person believed to be the owner. So whoever hired you, the client that hired you to do the project, their information must be on the mechanics lien form. The third bullet point, a statement that generally describes the kind of labor, services, materials, or equipment you supplied. A description of the work that you did. That information should be found in the mechanics lien form, and it should also be found in your particular contract. Name of the person who employed the claimant or requested the labor, services, and materials. This is, for example, if you are a subcontractor and you were hired by the prime, not only will you put the property owner's name, you will also put the prime's name in that mechanics lien form. At the top of page 15, description of the property. Now, a description of the property should have one from the plans, or if you go to the county recorder's office, there will be a description of the property there. The next bullet point, the claimant's address. So basically, the address of the property where the project was being done, you're also going to put your information on there as well. Proof of service affidavit completed and signed by the person serving a copy of the claim of the mechanics lien. Next to this bullet point, I want you to put page 16. Don't go to page 16 just yet, but next to this paragraph, literally in your book, I want you to put page 16. The reason for this is because this bullet point is talking about page 16, and we're going to get to that in just a second. But a proof of service affidavit basically means that you sent out the proper paperwork. They give you a receipt that says that you sent out the paperwork. You got to make sure you have that. You got to know when you sent out the notice, because when you submit your mechanics lien lawsuit, they will ask you for the proof that you sent out these forms. So we're going to go ahead and move forward to page 16 and 17, and we're going to discuss the two forms in regards to the mechanics lien. So on page 16, where it says notice of mechanics lien attention, this is the first form that will be sent to the client once you realize that the contractor is refusing payment or that the client refused payment. So for example, if you're the prime and the client is refusing payment, you're going to be filling out this form. If you're the subcontractor or the supplier and either the contractor is refusing payment and you tried reaching out to the client in regards to that, you're still filling out this form. So what is the notice of mechanics lien attention? It's a warning that if you remain unpaid, the next step for you will be going to the county recorder's office and submitting the mechanics lien on the property. So think of page 16 as a warning, right? You haven't done anything yet. You haven't done anything of legal value yet. You are simply just warning them. Now, this has to be sent via certified mail. You have to keep the little check stub, the little receipt that they give you, that you sent it via certified mail. Now, keep in mind, you're going to use this once the contractor is refusing payment or the client is refusing payment. That's when you start filling out this form and sending it via certified mail. When you send it to the client will talk to the prime if you're the sub, right? Hey, why hasn't the subcontractor been paid? And hopefully the client can put a little bit of pressure on the prime to pay you that money that is owed. Now, if you're the prime and you send this to the client and the client says, whoa, let's avoid all that. I'm going to give you that last payment. Perfect. You avoid the court. You avoid dragging this process out any longer, right? Because all you want as the contractor is to be paid. But remember, prior to you submitting the mechanics lien on the property, you have to send this information out. You have to send page 16 out. You're going to send this to the property owner, the owner of the property. And hopefully the owner of the property will put pressure on the prime if you're the sub, or if you're the prime, you send that information to the client. Hopefully the client stops, trying not to pay you. Hopefully the client wants to avoid the court, wants to avoid the lawsuit, and pays you your money directly. So remember, the notice of the mechanics lien must be sent out via certified mail. Now on page 17, that is the mechanics lien. Remember, the mechanics lien is not something crazy special form that takes a lot of effort to fill out. It really doesn't. It's really basic information. The lawsuit is complex, obviously, so you need a lawyer to submit the lawsuit. But the mechanics lien is a very simple form, right? We discussed what information has to be on it at the bottom of page 14 and the top of page 15. But basically, it's just saying that you as the contractor have not been paid, the type of work that you've done, how much money is owed. So what I'm going to do now is I'm going to give you the process of submitting your lien. For example, if you are the prime, you have to finish all the work in your contract in order to be able to submit the mechanics lien on the property. You must finish all the work in your contract. So if you're the prime, finish all the work in your contract. If you cannot finish the work because it's just too much money, you can go bankrupt, you can still sue them directly in court. So this is just in regards to the mechanics lien. So you have to finish the work in your contract, which means if you're the subcontractor, finish the work in your contract. If they're not wanting to pay you, we're going to go ahead and move on to step 2, right? But if you're the prime, you need to finish all the work in your contract in order to move on to step 2. Suppliers, as soon as the materials are installed, they can move forward with step 2 if they remain unpaid. Remember guys, all of this is thinking that the client is not wanting to pay you, or if the prime is not wanting to pay you. This is not something that you're going to do and be ready for like right away. No, this is just letting you guys know in the event that that happens, what are the steps that need to be taken in order to recover your money back. So I don't want you guys thinking, oh my God, I have to do this for every project. No guys, we're not doing this for every project. Just when we feel the client, if the client says, I can't pay you, I don't want to pay you, all right, we have the mechanics lien. If the prime is saying, I can't pay you, I don't want to pay you, all right, I'm going to have to start doing these things in order to recover my money back. Step number 2, send an unfiled or unrecorded notice of mechanics lien to the client, to the property owner, before going to the county recorder's office via certified mail. So what does that mean? Unfiled or unrecorded simply means that you're not going to a notary to, notarize that form. You're not going to the county and submitting that form. It is basically you filling it out and sending it directly to the client. Now, we do have to do it via certified mail to make sure we get that receipt, to make sure that we get that proof that we sent out page 16. So page 16, like I said, guys, you're not going to a notary. You're not going to the county recorder. You are simply just filling out that form and sending it to the property owner or the client, and keeping that receipt that you sent it via certified mail. So let's say you sent out that form, right? You give the client, the property owner, maybe a week to think about it. If the client hasn't reached out to you and you're calling them, they're not answering your calls, they're ducking you, then you definitely do want to do step number 3. So step number 3 is the mechanics lien. You're going to record the mechanics lien. You're going to submit the mechanics lien with the county recorder's office within 90 days of finishing the work, guys. So for example, you finish the work on Monday. On Tuesday, the 90 days start counting for you to finish the mechanics lien. That's why you don't want to let too much time pass before doing this, right? The client should be ready to pay you. The contractor should be ready to pay you by the dates on the contract. Remember, the contract is a two-way street between you and the other party. If the other party isn't holding up their end, that's a problem. So if the client, the contractor, are not holding up their end, that's a problem, and you need to start thinking about this. So what does record the lien mean? Record the lien simply means submitting the lien to the county recorder's office. Remember, the key thing right there is 90 days after you completed the work to submit the mechanics lien. All right, guys, so let's say you submitted the mechanics lien. They still don't want to pay you. You're calling them. They've obviously gotten a letter from the county recorder. Hey, a mechanics lien has been placed on the property. You need to lawyer up, or you need to pay the contractor the debt that is owed, or you can lose your property in the lawsuit. Let's say you're calling them. They're still ducking you. They still don't want to pay you. What is the next step? The next step would be perfect the lien. Anytime I say perfect, that means submit the lawsuit. So in this case, perfect the lien means you're submitting the foreclosure lawsuit to the court within 90 days of recording your lien, which means Monday you completed the work, Tuesday the 90 days start counting for you to submit your mechanics lien to the county recorder's office. Let's say 2 Mondays from then, 2 weeks pass, you go to the county recorder's office, you submitted the mechanics lien on the property. The day after, your 90 days start counting to submit your lawsuit. So you have 90 days to submit your mechanics lien and an additional 90 days for you to submit your lawsuit. If you don't submit your lawsuit, your mechanics lien will be void after 90 days. So you guys have to finish the process if you remain unpaid. Obviously, after the third step, if the client pays you, perfect. It's going to go void after 90 days. You can remove the lien from the property. But if you don't get paid, you have to submit the lawsuit. Because if you don't submit the lawsuit, your mechanics lien will go void after 90 days. So you got to submit the lawsuit if you remain unpaid. All right. So you submitted the lawsuit. Your next and final step would be submitting the les pens within 20 days of submitting your lawsuit. The les pens is a warning to any purchaser of the property that a mechanics lien is on it, which means if the property had a value of $80,000 and a mechanics lien of $20,000, they're purchasing the property for $100,000. They have to pay you out that value of your mechanics lien. Now, once you hit the perfect the lien part, once you hit that 4th and 5th step, you have to have a lawyer already. You need to contact a lawyer to help you finish this process. Again, this is the worst case scenario. Please, guys, don't start thinking that every project is going to be like this. It's not. These are extreme measures. These are extreme cases. Most of the time, you will get paid. I don't want you to stress out too much about this, but I want you to be prepared in the event that that happens. And again, some of this information does come out on the state exam. Focus on your keynotes. Focus where I'm telling you to focus. All right, so we've discussed the entire process of you submitting the mechanics lien. We discussed the 2 forms that are needed. Now we're going to go ahead and move forward to page 19. So on page 19, I do want you guys to highlight the first 2 sentences under where it says lien release bond. That is the first paragraph on page 19, where it says the consequences of a mechanics lien to an owner are potentially severe. First, the owner will usually not be able to refinance or sell the property until the lien is released. So we've already discussed that, but those are the consequences of having a mechanics lien on the property. I also want you to highlight the second sentence in the second paragraph where it says, an important counter strategy that the client may have to remove the lien from the property is obtaining a lien release bond. Now, this lien release bond has to be 125% the amount of the lien, which means if the lien was $100,000, the bond that they have to obtain is $125,000, right? So that they're not paying $125,000, guys. It's 1 to 3% of the overall value. Okay, so once they remove the lien from the property, at that point they have the option of refinancing the home or selling the home in order to pay you the debt that is owed. So the question would be, why would a client take out a bond 125% of the lien? Why would they do that extra step? Because if they get the bond, they remove the lien from the property, and at that point they can refinance the property, or they could sell the property to pay you the debt that is owed. Now, some contractors might think, well, what the hell is the point of the mechanics lien then? I just lost my money because they're selling the property. No, it's actually even better. Because of that bond guaranteed your money. So let's say the client decides not to pay you after all you have to do is sue the bonding company. Bonding company, of course, will ask you for the paperwork. Paperwork looks good. At that point, the bonding company will pay you out all the damages, and then they go after the client. I've seen this happen before in regards to the lien release bond. The bonding company actually works a lot quicker. They tend to avoid the court, as if the paperwork looks correct, they pay out a lot faster than the client would anyway. So if the client gets a lien release bond, it's actually to your favor, and you'd actually prefer them wanting to get the lien release bond because the bonding company guarantees your money, not the client. And in the last paragraph on page 19, where it says stop work order, here's another protection. Here is how we can legally cancel a contract in the event that the client is not paying us. So I do want you to highlight the entire paragraph in full. It has a lot of important information. We need to know this information, guys. A contractor on a private works project has an additional remedy if an owner fails to make a progress payment for the work performed. So they're already giving you guys some key important notes there. It tells you a contractor, which they're talking about a prime contractor on a private works project, residential and commercial, has an additional remedy if an owner fails to make a progress payment for the work performed. So from that very first sentence, you guys have to think about it like this. They're talking about the prime on private works. What are private works? Residential and commercial. The Civil Code gives the direct contractor the right to serve a 10-day stop work order if payment is not made within 35 days of the due date specified in the contract. So let's say, for example, You're working, your first progress payment is due, and your client says, I'm out of money, I don't have money to pay you right now. And then you're trying to give them some time, but now we're at 30 days, right? And the client's still, well, I don't have money to pay you. Once it hits 35 days late, you want to give them the stop work order. What does the stop work order mean? It means that if I'm not paid within 10 days of giving you the stop work order, I'm going to stop working, I'm going to pick up all my tools, I'm going to pick up the materials, I'm going to stop working entirely, leave the property, and go to court and sue you, right? So then if payment is not made within 10 days of service of the stop order, the prime contractor may stop work and seek an expedited determination of liability for payment from the local superior court. So what is that telling you guys? It's telling you that as soon as the progress payment hits 35 days late, you want to give the client a stop work order. Once the client receives the stop work order, you wait 10 days. If you're still not paid, stop working, stop what you're doing, go to court, submit your lawsuit. This is the legal way of canceling that contract because you were not paid. So no, you can't just be like, oh, well, if you're not going to pay me, I'm going to stop working. This is the step that you have to do as a contractor. Now, the question that I always get is, well, do I have to work the entire 30 days? Do I have to be finishing the project? You want to send someone at least once every 2 to 3 weeks just to clean up, make sure the project is looking good, make sure that everything is still in order, because you don't want to abandon the project either. I'm not saying you have to work the entire 30 days, but you want to send someone to check on the project. And it's going to make a little bit more sense in the next few pages. But this is the stop work order, guys. This is another protection the license offers you. All right, guys, now we're going to go ahead and move over to page 20. Chapter 3, page 20, and we're going to discuss the stop payment notice. So on chapter 3, page 20, we're going to be discussing the stop payment notice. Now, again, there's some good information found on those 2 pages, but I think it would be a lot easier if we kind of just focus on the notes. It's an easier way of explaining this information and also an easier way to understand it. So what is the purpose of the stop payment notice? The stop payment notice is a hold on the construction funds, and it can be used on private or public works. So basically, the stop payment notice will put a literal hold on the funds, delaying the project, because if there's no funds to do the work, the project will ultimately be delayed. So I really want you guys to think of it as that, and that would be a definition of it: a hold on the construction funds, or you can even say a lien on the construction funds. And again, it can be used on private and public works. Now, this is to recover a progress payment. So in the event that the prime isn't paid a progress payment or a subcontractor isn't paid a progress payment, a stop payment notice can be used. Now, if there's a lender involved in the project, all contractors have the ability for a stop payment notice, which means prime, subs, and suppliers. If there's no lender, only subs and suppliers have the ability for a stop payment notice. Now, if you have not been paid within 7 days of a progress payment, provide a stop notice to the owner/client. Wait at least 10 days. If you still haven't been paid, go to court and submit the lawsuit. So how does this work? Remember, guys, in your contract, you have to have a payment schedule. Now, if you are a subcontractor, you have to wait at least 7 days after the scheduled payment to give a stop payment notice to the client. So how would it work? I'm gonna give you guys an example if you are a subcontractor. So obviously there's a prime that hired you to do a specific job. You have to have a contract and there has to be a payment schedule attached. In that payment schedule, let's say for example, you needed to be paid March 1st, 2021. The prime contractor will have 7 days after the scheduled date to pay you your progress payment, which means at the latest, they have to pay you March 8th. Let's say March 8th comes around and the prime is still not ready to pay you. At that point, you have to give a stop payment notice to the client. Why to the client? Because you want to give it to the client because you are alerting them that the prime contractor has not paid you. Why does the client need to be aware of this information? Because at the end of the day, the burden of paying falls on the client. Because if you, a subcontractor, remain unpaid, you still have the option of putting a mechanic's lien on that property. Now, I know some of you guys are going to say, well, Luis, that doesn't really seem fair. I get it, and I 100% understand that. But at the end of the day, as a subcontractor, it is not your responsibility to figure out what's going on between the prime and the client. At the end of the day, your responsibility is to get paid. So whether the client and the prime have problems, that's on them. Your responsibility is to get paid. So yes, you give a stop payment notice to the client. That alerts the client. The client will put pressure on the prime to pay you. Now, if the prime still does not pay you, at that point, you wait 10 days. If after 10 days you remain unpaid, stop working, go to court, submit your lawsuit. Okay? So that's an example of how the stop payment notice works. Now, let's say you're a prime. Let's say you're a prime and there's a lender involved. If you're a prime contractor and there's a lender involved, a bank that gave a loan to do the project, you would give your stop payment notice to the lender. Why to the lender? Because the lender is paying the client, is giving money to the client to do that project. So the client has to have money because there's a bank giving them money to do the project. Now, the difference is if you are the prime and there's a lender involved, you have to get a bond of 125% of that progress payment. So for example, if the progress payment was for $10,000, the bond has to be for $12,500. Again, it's not going to cost you $12,500. It's a payment of 1 to 3% of that progress payment. Now, of course, if you win, they'll pay you all that money and you don't have to worry about the client anymore. Now, keep this in mind though. If there's no lender involved, a prime cannot give the stop payment notice. Only when there's a lender involved can the prime give the stop payment notice. As far as a sub or a supplier, you can give the stop payment notice whether or not there's a lender involved. So if it's just a prime, awesome. You give the stop payment notice to the client. The client puts a little pressure on the prime and hopefully forces that payment. Now, when you give the stop payment notice, it will be void after 90 days. So if you realize that you're not going to be paid either from the prime or the client, you need to submit that lawsuit. Because if you do not submit the lawsuit, it will go void. So remember, the purpose of the stop payment notice is to put a hold on the construction funds so you can receive your payment as soon as possible. If there's a lender involved, prime, subs, and suppliers can submit the stop payment notice. The prime will submit it to the construction lender, not to the client. If there's no lender involved, then at that point, the subcontractor submits the stop payment notice to the client. Hopefully the client puts a little pressure on the prime to pay you your money. If not, at that point, if the client still refuses payment, stop working, go to court, submit your lawsuit after 10 days of giving the stop payment notice to the client. And remember, it is void after 90 days. All right, you guys, now that we discussed the stop payment notice, we're going to go ahead and jump to page 27, chapter 3, page 27. Now we're going to go ahead and highlight that very first sentence, and now we're going to discuss the payment bond. Now, the payment bond is very, very simple. Let's go ahead and read it. The main purpose of a payment bond is to make sure there is a way of paying subs and suppliers in the event that the direct contractor fails to do so. So remember, guys, just a few pages back, I was saying, even if the client paid all the money to the prime, but the prime did not pay you, you still have the opportunity of putting a mechanic's lien on the property. And that's where the question arose, how is that fair? Well, one option the client has to protect their property is to ask the prime for a payment bond. What would be the purpose of the payment bond? It would guarantee the payment to the subcontractors and suppliers. So just in case the prime refuses to pay the subs or the suppliers, the payment bond company will pay off the subs and suppliers, meaning the client's property would be safe. So what do I need you guys to take away from this page? What are the main objectives that need to be learned from this page? I want you guys to take note. The payment bond is also known as the labor and materials bond. It guarantees payment for your subcontractors and your suppliers. Now, going to page 28. On page 28, I want you guys to highlight the first sentence in full, where it says, although a payment bond is optional on private works, it is required on public works when the contract is for more than $25,000. So that's a key thing that we have to know, guys. On private works, it's an option. If the client asks for it and you want the contract, then of course you have to get it. But on public works, there is no option. If the contract is $25,000 or more, you need to have this bond. So again, the payment bond is nothing to be too overly complicated, right? The payment bond guarantees payment for subs and suppliers. The client requests it from the prime to protect their property. It's also known as the labor and materials bond. And of course, on public works, the payment bond is mandatory on any contract $25,000 and up. On private works, residential and commercial, it's an option. Now we're going to move forward to page 30, chapter 3, page 30. Now I want you guys to highlight the first paragraph under where it says notice of non-responsibility. Now right here, let's go ahead and read it. A notice of non-responsibility is a written statement signed and verified by the owner or owner's agent informing potential claimants that the work described in the notice was not authorized by the owner and that the owner will not be responsible for payment. This is very common when there's a tenant involved, or you can say renter involved. So let's say, for example, you get called to a property, let's say a standard residential property. You realize that you're not dealing with the owner of the property, but you're dealing with a renter. And let's say it could be a painting, let's say a remodel. They want to remodel the house for some reason. So a little bit of paint, tile work, flooring work. Let's say the owner arrives to the property and they realize that there's work being done. At that point, they can put a notice of non-responsibility where the project is being done. Basically, they can tape it to the front door. And they also have to send you a copy of this form by certified mail, personal delivery, or let's say FedEx, which is basically certified mail. What is that saying? What is the notice of non-responsibility saying? It is simply saying you, the contractor, are working with a renter. You are not working with the owner of the property, which means if the renter decides not to pay you, it is not the owner's responsibility to pay you the money that is owed, because you, the contractor, are not working with the owner of the property. You are working with the renter. Now, keep in mind, most of these instances, most of these examples are for smaller jobs, because if you think larger jobs require permits, the owner would actually have to sign off on the permits. Now, in the second paragraph, I also want you to highlight those two sentences in full. The first sentence tells you how they can deliver the notice of non-responsibility, but the second sentence also tells you it must be posted in a conspicuous place at the job site, basically on that front door of the property, and recorded within 10 days after the owner first learns of the unauthorized work. So remember, if the owner never finds out about the work, then they are not held responsible for that work anyway. If they find out about the work, then they have to give the notice of responsibility to tell the contractor, you're not dealing with the owner of the property, you are dealing with a renter. So in the event that the renter refuses to pay you, you have to sue the renter directly in court. I, the owner, will not be held responsible, which means you cannot place a mechanics lien on the property. Now, at the bottom of page 30, that very first paragraph, I want you to highlight that first paragraph in full, and we're going to discuss a notice of completion. This is a different form. It's called the notice of completion. What is the notice of completion? Well, it's in the name, right? The work has been completed. This form is also known as the notice of acceptance. How do you want to do this? You walk the job with the owner. You ask them if everything turned out correctly. If they have any questions, if they have any doubts, if the owner says, you're good, thank you very much, they're ready to issue your last payment, you have to have them sign a notice of completion, also known as the notice of acceptance. They are accepting the work. Walk the job with the owner, ask those questions, have them sign the form. You, the contractor, will stay with the copy. You give them the original. This is where I want you guys to pay attention. The owner has 15 days from completion of the work to submit it with the county recorder's office. The owner, the client, has 15 days from when you completed the work to submit that form to the county recorder's office. Now, the contractor does not do this step. The owner / the client does this step. Why is that important? It's important because it is possible that it will change the deadline to your mechanics lien, which means if you were paid in full, it does not matter if the owner submits this form. If you were paid in full, it does not matter if the owner submitted this form. If you were not paid in full, then it does matter, and it changes the deadline to your mechanics lien. So if you're the prime contractor, you no longer have 90 days to submit the mechanics lien. You will now have 60 days to submit your mechanics lien. If you are a subcontractor or a supplier, you no longer have 90 days. You only have 30 days to submit your mechanics lien. I'm going to say that again. If everyone was paid in full, it does not matter if the owner submits this form. If you were not paid in full and the owner submits this form, it changes the deadline to your mechanics lien. Which means if you're thinking you have 90 days and you're not paid in full and you let 60 days pass and you're a sub or a supplier, you lost your payment. You have to be aware of this. But when would you have to be aware? If you're not paid in full. If you're not paid in full, that's a red flag. What are my dates? What dates do I have to remember? If you're the prime, 60 days to submit your lien. If you're the sub or the supplier, you have 30 days to submit it. Now that's the notice of completion. There's another form known as the notice of cessation. What is the notice of cessation? Okay, I want you guys to highlight that last paragraph in full as well. It tells you, the second sentence, we'll start there. The notice of cessation is an official declaration that work has stopped. It is similar to the notice of completion. Both statements must be written, signed, verified, and recorded, and both have the effect of shortening the time claimants have to record liens or serve stop payment notices. However, a notice of cessation may only be recorded after work has stopped for 30 consecutive days whether or not it is complete. So this is an important thing to remember. A notice of cessation will be filed by the client, not the contractor, by the client. And it's letting the county know that the contractor did not finish the work. Now, the reason is not important. So I don't want you guys to get too hung up on the reason. I want you guys to remember, in order for the client to submit this form, 30 consecutive days must pass prior to them being able to submit this form, which is why a couple pages back, I told you guys, send someone every 2 to 3 weeks just to make sure you're not abandoning the project, right? So let's say the client's telling you, well, just give me until next week or 2 weeks from now or 3 weeks from now. It is possible that they're delaying it because they want to submit a notice of cessation. But we're not going to play that game here. We're going to send someone every 2 to 3 weeks until we can submit that lawsuit in the court. The notice of cessation is saying that you abandoned the work. The work was not completed. Okay? So in order for them to submit the notice of cessation, 30 consecutive days without work must pass in order for them to submit this form to the county recorder's office. If the client submits this form, it will once again change your deadline. The prime will have 60 days. The sub and the supplier will have 30 days. Stay on your toes. If they don't pay you in full, that's the red flag. You have to keep on top of it. If you're paid in full, then you're fine. Don't even worry about it. All right, you guys. Going to page 31, I want you guys to focus on the third paragraph. Third paragraph, highlight the first 2 sentences where it says, everybody has 90 days if no notice of completion or cessation is filed. If such a notice is filed, the deadline is shortened to 30 or 60 days. So keep that in mind, you guys. Everyone has 90 days to submit a mechanics lien unless a notice of completion or notice of cessation has been filed. If a notice of completion has been filed, primes only have 60 days to submit a lien. Subs and suppliers will have 30 days. If a notice of cessation was filed or a notice of completion was filed, I'm going to repeat it. The prime will only have 60 days to submit a lien. Subs and suppliers will only have 30 days to submit it. And then we're going to go ahead and move forward to page 33. Now on page 33, we're going to go ahead and focus on the last paragraph where it says waiver and release. And I want you to highlight that very first sentence where it says, when construction bills are paid, the owner, lender, or direct contractor may require a sub or supplier to sign a waiver and release rights to a lien, stop payment notice, or payment bond. We're going to talk about that in the next page. Let's go to page 34, and I want you guys to highlight number 1 through number 4. Now, these are called waiver and release forms. Please make a note of this. What is the waiver and release forms? A client can make all parties sign it, prime, subs, and suppliers. What is the point of the form? It releases your right to the mechanics lien, the stop notice, and a potential lawsuit in court for that payment only. Okay, for that payment only. Is that confusing? I'm gonna go ahead and try to give you an example to understand it. Let's say, for example, a contract is for $100,000. There's 4 payments in total. $25,000, $25,000, $25,000, $25,000. Let's say they pay you the first 3, right? That means there's only 1 payment left. They paid you the first 3, $75,000. They make you sign a waiver and release form for each of those payments. Why? Because let's say they don't want to pay you the last payment and you have to place a mechanics lien on the property. Are you submitting it for $100,000? No, because you signed waiver and releases for the first $75,000 because they paid you that money. You can't place a mechanics lien for the entire project if they paid you certain progress payments. So the waiver and release releases your right to the mechanics lien and the stop notice for that particular payment only. Okay? So there's two conditional forms and two unconditional forms. When it says conditional, the condition means they're paying you in a check. You're not losing your right to the mechanics lien or the stop notice until the check clears in the bank. Which means if you make them sign a conditional waiver, they give you a check, you go to the bank, it does not clear in the bank, you still have your mechanics lien. You still have your stop notice. Unconditional waiver means they're paying you in cash. Okay, and the cash is not in the bank. The cash is not, let's go to my house and pick it up. The cash is in your hand, not at the ATM. The cash is in your hand. Okay, so remember, conditional, they paid you with a check. Unconditional, they paid you in cash. Here's another thing though. Please sign the correct form, because if they pay you in a check and you signed an unconditional waiver, the check didn't clear in the bank, you lost your right to the mechanics lien and the stop notice. You can still try to sue them in court, but you lost your right to the lien and the stop notice. Please sign the correct form. Now, in the last paragraph, the first paragraph under number 4, let's go ahead and read it and highlight it as well. If you have any doubts about signing a waiver and release, by all means request a conditional form and or consult an attorney. In the case of an unconditional release, you may lose your rights to a lien, stop notice, or payment bond if the check bounces. If that happens and you are not paid, you will have to file a standard breach of contract lawsuit in court. The only reason a contractor would sign an unconditional release as opposed to a conditional one is if the cash is in their hand. Everything I just explained, you guys. Everything I just explained. Sign the correct form, please. Okay, sign the correct form. Now, under where it says lien release, go ahead and highlight that very first paragraph where it says, if a contractor files a mechanics lien but afterwards is paid, the owner will undoubtedly ask for a written release of the lien. The contractor is required to record the release of the lien, but in practice, it's usually given to the client to do so. So what are they talking about there? What they're basically stating is, let's say you submitted a mechanics lien on the property, and then the client pays you. So you did step number 3. You went to the county recorder, you submitted the mechanics lien on the property. Then the client calls you up. You know what, let's avoid the court, I want to pay you in full. Awesome, you go to a notary, you have the notary make you a form. I, Luis Gonzalez, and Luis's Painting are removing the mechanics lien from their property because they are paying me in full the $10,000 that was left in the contract. You sign it, the client will sign it, they pay you your money, they take you your fingerprint. The issue becomes here that what if the client says, well, can I do it in payments? No, you can't do it in payments. Why? We already had a payment schedule and you broke that payment schedule. You need to pay me in full. Okay? Now, I also want to add a little bit more information in regards to the waiver and releases. And I want you, this information is in your notes or you can add it to this page. Now, keep in mind that each worker or laborer must sign these forms. These forms are also known as lien releases. When signed, prime subs and suppliers lose their rights to the mechanics lien and that stop notice for that payment only. So check your notes, you guys. I added it in the notes, or you can add it to this page as well. Okay, so now we're going to go ahead and move forward to page 36. So we're going to be on chapter 3, page 36. And I want you to highlight the second sentence in full, where it says, the process of finishing or executing any of these actions in court is called perfecting it. So remember, you guys, earlier in the class, I stated, if you have to perfect the lien, that means you have to submit the foreclosure lawsuit. So anytime that you guys see perfect the lien or perfect the stop notice or perfect the payment bond, that word, that term perfect, that means you are submitting the lawsuit. That word, that term, perfect, that means you are submitting the lawsuit. Okay. Now, in the second paragraph, under where it says lien foreclosure lawsuit, I want you guys to highlight those first two sentences where it says, if the lien is for $25,000 or less, it is filed in Superior Court, Lower Division, as a limited civil case. If the lien is for more than $25,000, it is filed in Superior Court, Upper Division, as an unlimited civil case. Okay? And in the last paragraph, I want you to highlight that first sentence where it tells you, you must also record a les pens notice within 20 days after filing a lien foreclosure lawsuit. The les pen notice is a warning to subsequent purchasers or claimants of a lawsuit. Sorry, the les pens notice is a warning or subsequent purchase or claimants that such a lawsuit has been filed against the property. So we've already discussed this way back when we were discussing the mechanics lien. But if you're wondering, where did I get this information? All the information I get is from the law book. That way you can just go ahead and highlight that there. Going to page 37, where it says stop payment notice lawsuit, I want you guys to highlight that second sentence. We've already discussed this, but they did add a little bit more information here. So remember, when you're going to do a stop payment notice, it is void after 90 days. So when you give a stop payment notice to the client to alert them that you have not been paid, you have to wait at least 10 days prior to you going to the court and submitting your lawsuit. We discussed that already. But let's say you did submit the lawsuit, you have to notify the client that you did so within 5 days. So let's say you were not paid. You gave a stop payment notice to the client. The client still did not pay you within the 10 days. That means you went to court and you submitted your lawsuit. You have to notify the client that you submitted the lawsuit within 5 days. Okay, now we're going to go ahead and go to page 38. Now on page 38, in the second paragraph, I want you guys to highlight that first sentence where it says, this lawsuit may be filed at any time after you complete work, but it must be filed within 6 months of the deadline for a stop payment notice. Now, you guys, this is telling you what happens where there's a payment bond on the contract. So remember, the payment bond guarantees payment for subs and suppliers, but you do have to sue the bonding company. You just have to submit the lawsuit. They ask you for your paperwork, and more than likely, they will settle out of court. They don't want to go to court, especially if you have your paperwork in order. But what this is telling you is you have to submit the lawsuit within 6 months for public and private works. So if you're submitting a lawsuit when there's a payment bond in the contract, you have to do it within 6 months. And in the last paragraph on page 38, this is again where I go ahead and discuss this all over again. You guys, these are your protections the license offers you. These are absolute worst case scenarios. There are some things that we have to do no matter what, like giving the preliminary notice. But the stop payment notice, the mechanics lien, the stop work order, those are worst case scenarios. Those are when the client tells us, I'm not going to pay you. This is when contractors, the prime tells us, I'm not going to pay you. If they're going to decide to do that, well, they better make sure that they know that they will ultimately be sued if they're not willing to pay us the money that is owed. This is for your protection, guys. So let's say, for example, let's say you submitted a mechanics lien on the property. The mechanics lien lawsuit, you submitted the lawsuit as well. Now, let's say the court sold the property in the auction, but it wasn't enough to cover the debt that was owed. Let's say, for example, the property sold for $100,000, but the client owed you $150,000. What is the next step? Let's go ahead and read it. Winning a lawsuit, unfortunately, often not the last step in recovering money owed to you. There's still the matter of collecting it, especially if you won in small claims court. One strategy is to request a bank account or other real property be attached. Show the written court judgment to the court clerk and ask for a writ of execution. The sheriff or marshal is then instructed to collect funds in a bank account or seize property to be sold at the auction. If you cannot locate assets to collect on, go back to the court clerk and ask for an order of examination, which requires the losing party to reveal under oath the location of assets. Because of the difficulty in collecting on many judgments, it is prudent practice to keep a photocopy of checks received during the project, so you record an important bank account numbers, the bank branch, etc., that may come in handy later on when you begin collection procedures. Basically what that is stating, let's say they sold the property and it wasn't enough to cover the debt, you would ask for an order of an examination at that point, which means they will make sure that they locate assets like bank account with more money or other properties that can be seized and then sold to pay you off the debt that is owed. Again, guys, this is worst case scenario. I don't want you guys to think it's going to happen at every project, because it doesn't. But this is the procedures that will happen in the event that the contractor or client refuse to pay you. Keep in mind, you guys, once you guys get to this step, you have to have a lawyer already. You don't want to be asking for an order of examination by yourself. The lawyer will handle that for you to locate other assets that can be sold or recovered to pay you the debt that is owed. All right, guys, that is chapter 3. I know it's a lot of information. I know it's confusing. Repeat the class over and over again until you understand it. Thursday, you receive your practice exam regarding chapter 3 only. And please study as much as you can. Thank you guys very much for your time.